Well, welcome back from lunch for those of you here on site, and good afternoon, and welcome back to those of you on the web. We're back to our hearings on the FTC's role in the changing world. My name is Elizabeth Krause. I am the Deputy Director for International Antitrust here at the FTC, and I'm delighted to be co-moderating this session on effective international engagement with Dion Woods-Bell, Counsel for International Consumer Protection and Data Privacy here at the FTC. This session should really prove particularly interesting as it's going to allow us to hear directly from our foreign agency counterparts on what they find makes for effective international engagement. We're eager to learn from our sister agencies about their successful strategies and tools for engagement with foreign counterparts. And of course, we're also interested in hearing their perspective on what has not worked as well and why, with a view to seeking how we might further develop the FTC's international tools and programs to ensure that they're fit for purpose for the 21st century. We're really honored to have this incredible slate of seasoned enforcers from truly diverse backgrounds to provide their insights on these issues. Their impressive biographies are listed on the website as well as outside in print copy. So I'm really just going to give a brief introduction, starting with those closest to us and moving down the table. So first, we have Paula Farina Azevedo, from CAGE, Brazil, Brazil's agency, and she's a commissioner there. Next, we go to Tunde Iroquera, the Director General from the Consumer Protection Council of Nigeria. Following Tunde is Hanli To, the Chief Executive and Commissioner of the Competition and Consumer Commission of Singapore. Following Hanli is Chris Warner, who's the Legal Director of the Competition and Markets Authority, the CMA, from the UK. The tall man after Hanli is Rainer Wesley, who's responsible for EU-US cooperation in competition and justice policies at the delegation of the European Union to the United States. And last but truly not least is Stephen Wong, the Privacy Commissioner in the Office of the Privacy Commissioner for Personal Data in Hong Kong. As with our other sessions, for those here in the audience, we will take questions from our audience and have note cards available in the room that will be passed out for your use. With that, I'm going to turn to Dion to kick off our session.
Thank you, Liz, and thank you to our esteemed panelists. So we're going to start off the first round with asking our colleagues to please share your key strategies and tools that you've used for successful international engagement. I'm going to ask you to be brief because we'll come back with other questions. Please, over to you, Paula.
Thank you, Dion. Thank you, Liz. I think in Brazil, our main tools for successful international cooperation are our MOUs that we've signed with over 20 jurisdictions and our interactions in multilateral and regional fora. Through these tools, we've been able to not only foster relationships, but also cement existing ones and really consolidate best practices and promote legislative change within Brazil. And I think we can talk more about this later on, but that's the highlight.
Thank you very much. Over to you, Tunde.
Well, thank you very much. And I'm wearing two different hats now, so I'm going to talk a little more on what our experience has been, which is actually an old law that was repealed about 2 months ago. But that provision is still, there's an equivalent in the new law. And essentially, there is actually a statutory mandate to cooperate with other agencies internationally. And so proceeding from that, essentially in fulfilling the mandate, you have to work with other agencies. And one of the things we've used a lot is, again, like she said, the Memoranda of Understanding. And we have one with the FTC and another agency in Nigeria. And then what we've also found is the right fora. There's an African dialogue that is also promoted and actually supported by the FTC. And what that allows, what that has helped us to do is to realize that the problems are pretty similar across the different countries in the region. And so just getting that sense of understanding and getting to share notes and then building relationships that you can leverage on to gather information sometimes, or to at least just discuss experience and provide context has been very helpful. Thank you.
Thank you very much. Hanli, thank you.
Thank you, Dion. I fully agree with what Paula and Tunde have said about MOUs and the interactions at the international fora. I just want to add one additional piece which has been very useful for us, which is the regional free trade agreements. In particular, I see Rod Sims in the audience, so I want to highlight the ASEAN, Australia, New Zealand Free Trade Agreement. And under that free trade agreement with the 10 member states of ASEAN, including Singapore, we have the CLIP program, which is the Competition Law Implementation Program, and to which Australia and New Zealand have provided very significant support and assistance to the member states of ASEAN, including secondments, expert placements, capacity building, and e-learning. So I think that's been very good for us.
Thank you very much. I have to congratulate you all. You're moving quite swiftly. You did have more time, so if anybody wants to revel in the comments a little bit and then circle back to our previous colleagues, please do feel free. Chris.
Well, thank you very much. First of all, can I say thank you for inviting the Competition and Markets Authority here today. And I should add the caveat that, as other speakers have, that the views I express are my own and not necessarily the views of the CMA, although, like others, I hope they're not going to be too misaligned. So I wanted to take a slightly different slant, if I may. I mean, the CMA is very active in the international arena. We participate in the international and European consumer enforcement networks and in international and European policy networks, and we do a whole range of bilateral works and technical assistance and secondments and things that we can talk about in a bit more detail as we go through. But I wanted to reflect on some of the strategies we've found, or some of the approaches we found have been quite useful in terms of making the most out of those fora. And I wanted to highlight just 2 or 3 of those. The first thing I think I'd like to highlight is I've called it focusing on outcomes. And 2 or 3 years ago, the CMA was the president of IcePen. And I think one of the things we wanted to make a concerted effort to do when we took over the presidency was to focus on outcomes. And I suppose how I describe it is that there was an awful lot of very useful discussions happening, and we wanted to shift the debate slightly in terms of moving it from kind of what have we done to what can we do together given what we have done. And I think people in the room will be able to correct me, but I think that has identified that there has been a shift and has helped identify some opportunities to work together, and it feels it's brought agencies together. And a good example was some work on online reviews that we did, which I can touch upon later, where we took the project that we'd done in the UK and we helped the IcePen members roll out some guidelines for a number of parts of the industry which can be rolled out across the globe. The second thought is that it was worth focusing on the harm. So I think given there's a range of divergences across the world, it's been very helpful, I think, to focus on the harm, which is enabled rather than the legal infringement, and that's enabled us to focus on areas of common ground rather than areas of differences. So I think that's something worth doing. And the third area, I think, which has been very helpful is looking inwards as well as looking outwards. And by that I mean thinking about the wealth of work we do at the CMA and make sure that we are joined together and thinking about how they supplement each other and can be used on the international arena, but also thinking about the UK as a whole and making sure we're joined up there. And just one example is last year we held a conference involving all the organisations involved in competition and consumer policy across the UK to see what we could do better on the international frame arena. And there were 20 organisations in the UK alone who have got international touch points in those arenas. And I think it was really striking to everyone who participated that there are so many touch points and just the potential benefits of working together more collaboratively. So I shall stop there.
Thank you very much. Rainier, what can you add to the conversation here?
Well, first of all, thanks for having me. International cooperation on all three fields, let it be consumer protection, data protection, but also competition enforcement, is an essential part of our international and day-to-day enforcement strategy. So we would not be successful enforcers would we not have our international outreach and cooperation. The main objectives that we see in this kind of cooperation is that we want to be, first of all, able to quickly address violations together with our international partners, also in order to increase deterrence. We want to be able to minimize the risk of conflicting findings, for example, when it comes to merger assessments and when it comes to remedies. And we want to make emergent authorities efficient and effective enforcers in their own rights. I have to admit that we in the EU are probably very privileged in that regard because international cooperation is built in our system. We work on a daily basis with the consumer protection authorities, with the data protection authorities, and with the competition enforcers of 28 member states, and we work in 24 different languages. So that provides us a very good training ground also for the broader international context. I will try to focus my remarks today more on the work that we do in competition enforcement, because that is the only field where the Commission actually has a direct and exclusive competence. We only coordinate the work of our consumer protection authorities and of our data protection authorities. When it comes to competition enforcement, there's a significant number of cases where we work together with international parties. If you look at the period between 2016 and 2017, we coordinated with other agencies in more or less 55% of our cartel, of our antitrust, and our complex merger investigations. Looking at the three different types and levels of cooperation, I think most importantly we have our European regional cooperation. That's the European Competition Network, the ECN, which is probably as close as it can get in terms of international cooperation, because we enforce the same rules and we have to make sure that we have the same interpretation of our rules. We have the second level, which is the ICN and the OCD. The ICN, as such, is a success story in itself from 14 authorities that created it in 2001, and now I think we are at more than 100 members. And the third level is bilateral cooperation, where we have technical competition cooperation with a number of agencies. Our first generation agreements, the first one that we had was with the US, with the FTC and the DOJ, with Canada, Japan, and Korea. We now also have started to have second generation agreements that allow us actually to really exchange evidence on specific cases. We have that with Switzerland, and we're quite advanced in our negotiations with Canada and with Japan. We have a lot, and Paulo already referred to that, we had a lot of MOUs, we call them nowadays administrative agreements, with all the BRICS countries. So we have them with Brazil, Russia, India, South Africa, with China, as well as with Mexico. We have technical programs with some states. We all have a technical cooperation with Asia, and we have more and more references to competition also in our trade agreements. So we have competition chapters in 14 trade agreements around the world. To sum up, we see that we have a very, very close network in our international cooperation, which I think has allowed us over the years to speak the same language amongst the enforcers. That does not mean that we always say the same things.
Excellent. Commissioner Wong, please.
Thank you. Given the fact that my office is entirely an independent statutory authority, regulatory authority, independent of the government, and also the fact that Hong Kong has a very different system, including a different legal system from the mainland of China. And we do have the benefits of having unique advantages or attributes in relation to data protection. I must emphasize that my office is responsible for personal data only. Privacy is regarded as a fundamental human rights in Hong Kong, but I don't have any authority over competition or consumer protection. There are different bodies regulating these issues. We pursue effective international engagement largely through one, what we call the established channels, and the other one is the ad hoc channels. The established channels originate from the three international agreements or arrangements Hong Kong had entered into, and that is the APEC Cross-Border Privacy Enforcement Arrangement, and the second one is the Global Privacy Enforcement Network Action Plan, and the third one being the International Conference for Data Protection and Privacy Commissioner Global Cross-Border Enforcement Cooperation Arrangement. Very long name. The acronym is ICDPPCA. Still very long. and these established mechanisms provide means and the tools for cooperation, in particular in relation to the sharing of information and also to a certain extent sharing of evidence as well. But we do enter into ad hoc arrangements with individual DPAs, for example, Australia, Holland, and sometimes, in fact, on previous occasions, we've entered into ad hoc arrangements with the United Kingdom and the FTC. And on specific cases, bear in mind that Hong Kong is also an international trading center, international financial center, logistics centers, like Singapore. We are at the top of everything, in the world, and that's why somehow, people in Hong Kong are involved, in the data breach incidents, for example, the multinational data breach incidents. We have an interest in those cases. So we managed to get into some sort of informal ad hoc arrangements with the states or jurisdictions concerned. But certainly, this is something that we can pursue further in order to refine, the framework or the network of international cooperation.
Thank you. Fascinating. And so from that discussion, we got a panoply of different opportunities to pursue engagement with foreign counterparts, administrative agreements and MOUs, multilateral frameworks, looking at technical cooperation as a tool, new laws that come into force and to provide new powers, focusing on outcome-driven determinants, and then looking at collective harm and seeing where we might find common ground, coordinating with other sister agencies, and then taking a look to minimize the risk and avoid divergent outcomes. We've taken a look at those, and I don't know if you, Paula, or you, Tunde, especially because we started over here and you were quite swift. Do you want to respond to anything any of your colleagues have said?
I think just picking up on some of the things that they said, I think one of the issues that was pointed out by Chris at the CMA is the issue of what can we do together. So I think that's something that we've been particularly interested in at the regional level. As you know, Brazil has had an interesting development in the past few years, and we've reached a certain level of maturity due to international cooperation that we received from our counterparts. From more developed agencies, and so we feel that right now it's our duty to also help other agencies in the region, especially those that are either reviewing their antitrust laws or with newly developed agencies, to also reach this level of maturity. So what can we do together? We've been helping a lot of agencies through international cooperation to revise their soft law, revise their legislation. We've been doing a lot of capacity building, and I think that's something that's extremely important in international cooperation, and that's something that we have to continue to build on.
Thank you. Thank you very much, Tunde.
Well, yeah, thank you. The one interesting thing that I've learned from this is there are quite a number of regional cooperations that already exist. And what a coincidence. In Africa, at least in West Africa, and then even the entire continent, we're on the cusp of learning that. Only recently, the ECOWAS, which is the Economic Community of West Africa, established its own competition authority in Banjul, Gambia, and that's become operational only in a matter of months. And the whole continent is also negotiating its own continental free trade agreement, which has been signed by many countries. Nigeria hasn't, and still working on that. As a matter of fact, the second round of the negotiations, which includes the competition law aspect, is just about starting. So it's interesting to hear what these regional experiences are, so that at least we can watch out for that as we go.
All right. I think we have opportunity for one more colleague to respond. Hanli, you also moved very swiftly. Do you have any thoughts? We'll go deeper later, but just your initial impressions, please.
Actually, I thought it was interesting for us because we've just started doing consumer protection not even 1 year. And I was sharing it today. They've been doing consumer for 20 years, but they've just started doing competition. So it's quite nice. We can have a very good mutual exchange.
Convenient, we seated you side by side, right?
Yeah. But I think for us, because we've been doing competition for a number of years, and a lot of dual agencies in the world, we were able to leverage on our contact base to learn the consumer side much quicker, including the FTC. We had a senior economist, Janice Papalando. She came down last year and did a session with all our staff, and it was great. We've done work with the Australians and as well as the UK CMA. So again, because we already had the contact base in competition, it was very easy to leverage onto consumer.
That kind of picks up on the human glue issue that was raised yesterday, and how developing the relationships actually fosters further relations and convergence and cooperation. But I'll flip it back to Dion.
No, that's completely fine. I think we're moving in the right direction. So with all those comments on the record, what we've done is now we've picked up 3 buckets, and we're going to move over to the 3 buckets. And it's actually great that, Hanli, that you started to mention that, because we're going to look at domestic priorities and how they might motivate international engagement. We're going to look at some differences and similarities and explore a little bit more if you have a competition regime, or if you have a consumer regime, and what that's like. And then finally, we're going to look at regional multilateral fora and maybe dip our toes into bilateral issues if we have enough time. Liz?
Terrific. Well, maybe I'll pick up on the first theme that Dion mentioned, and that's the one of domestic priorities motivating international engagement. And Chris, I've heard you speak on this in the past, so maybe I'll pass the mic to you to start off, and then we'll get a little dialogue going.
So a lot of the CMA's international work is founded in its domestic priorities, and there's a lot of work we do around unfair terms and the digital economy. So it got me thinking, well, is that the right approach? And I've come to the conclusion it is, obviously. It's unfortunate for me to say no. But it's quite easy, I think, at first blush to kind of say that's quite a selfish approach to international engagement. And I suppose my reflection on that is I think that's it makes an awful lot of sense. At one level, we've got limited resources, so we need to focus somewhere. But also, I think, looking at our domestic priorities, we wouldn't be doing our job properly there if we're not thinking about the international dimension. It's not a great outcome for the consumers we're seeking to protect if we just move the problem along, for example, or don't help our sister agencies. But I also think it makes an awful lot of sense in terms of it's the area we spend most of our time working on. As an agency, and so it's where we've got the most to offer and the most to share, and where we can provide the in-depth knowledge and experience, which I think is really good news for others. And as a practical level, I think, in terms of getting sort of organisational buy-in and support for kind of international cooperation, it's where you can get most bang for your buck, as it were, because the additional workload is limited over and above your domestic project work, but actually you can deliver quite a lot of value and support more broadly.
Thank you. I was wondering if Paula might have anything to add to that.
Yeah, I tend to agree with Chris. I think our domestic priorities truly do influence our international engagement, and I think Brazil is a very good example of that. And our recent OECD accession is an example, I mean, a crystal clear example of how international cooperation can be used to further domestic engagement. And so what happened in Brazil was we, up until 2011, we had another competition law in which we did not have a pre-merger notification regime. So we needed several changes to our legislation. We needed congressional approval. We needed support internally, and we were having a very difficult time finding that support. So at the time, the people at CAGI and the CAGI president and commissioners, what they did was they decided to look outside of Brazil for best practices, began benchmarking, and decided to request a peer review at the OECD. And the first peer review very helpfully pointed out absolutely everything that was wrong with the Brazilian competition system. And while some outsider might look at that and say, well, how humiliating for CAGI, we actually found it absolutely wonderful, because that was a way that we were able to go to the legislature and say, we need help. We need to actually promote change in our legislation. We need to enact a new law. And this truly helped us to change our law. And we've done this on several occasions, either this was the clearest example of the way that we promoted a huge legislative change. But we've also done this on a smaller level. We've had, for several years, we've had difficulties in dealing with the Brazilian Central Bank on mergers involving the financial sector. The OECD has had several papers published by several different countries on how these countries have dealt with financial institution mergers and how their competition agencies have been interacting with their central banks. So based on these reports that are issued by our sister agencies and our counterparts, and we've been speaking to several of them, we were able to negotiate an MOU with our central bank, which was very successful and which basically remedied lots of our, basically all of our problems. And yesterday we were able to finally accept the invitation to become a permanent member, an associate member of the Competition Commission at the OECD. And one of the main obstacles that we had was precisely the review of financial institution mergers. Another way in which our domestic priorities motivate our international engagement is through the cases that we're currently handling. So, for example, there are several new issues that are coming up right now in Brazilian antitrust law. We have a globalized era, we have digital economy, and a lot of the problems that we're seeing in Brazil, a lot of the new conducts that weren't there before, maybe 5 years ago, 10 years ago, are also being seen around the world. And it's very helpful to be able to pick up the phone and call our counterparts and say, you know, what's the theory of harm? Does this make sense to you? Does this conduct seem like it will affect the consumer welfare in your country? And this kind of exchange is very important for competition agencies such as CAGI, because in a lot of cases, this is the first time that we're looking at a certain conduct or a certain market, and having the experience of other agencies that have already looked at these markets minimizes what I can only call growing pains. So it minimizes errors, and mistakes made in competition areas is ultimately very costly to the economy, especially an economy such as Brazil, which at the moment is not growing as rapidly as it could be. So minimizing errors, not impeding innovation is something that we're very attentive to, and this is something that has been very helpful through international cooperation.
Those were absolutely terrific, kind of spot-on examples. We're going to, because we want to move on with a number of themes, I'd just note that they also bring out a number of the issues that were raised yesterday in relation to cooperation, and also pick up beautifully on the prior panel regarding the impact of soft law and developing hard law. So thank you. But I'm going to pass over to Dion right now for our next theme.
Thank you. We foreshadowed this theme before. We want to go over to Tunde and to Han Lee, and we want to talk about differences in having a consumer protection agency that acquires competition authority and then having a competition authority that then acquires consumer protection agency. But more globally, what we want to talk about is how you use your tools in one area and how they might influence or inform another area. And we're going to ask Commissioner Wong to follow up with some observations after you talk. And I want to give a nod to Commissioner Trevisan, who mentioned building a house while you live in it. I think in both of you, in your instances in Nigeria and in Singapore, you're going to have to build your houses while you live in them. How are you going to manage this, gentlemen?
I'll let him go first. Maybe I'll
I remember when my my ministry told me, hey, you're going to take on consumer protection, and I just want to tell you that these consumer protection folks are different from the competition people. So I wasn't sure what they meant by that, but I guess the first point is that most of them are not lawyers or economists, right? So that's obvious, and so they have a different background. But what we've been really focusing on is the integration, and actually the agency which I learned a lot on integration with the ACCC in Australia. One of the first visits I did was to visit the ACCC, and Rod and Marcus were very good in hosting and sharing everything which they did to integrate the case team. So I think there is a lot of complementariness. One of the things we started doing is market studies with consumer protection people inside. And in fact, the recent one which we just completed on online travel has a very heavy consumer focus on that, things like drip pricing and that kind of stuff, and subscription traps. And in terms of the international engagement, when I mentioned Janice, she was really useful. She came down for a week and she did a workshop for us. That was great, and shared about the Volkswagen case and how they got redress for consumers. So I think yeah. So as part of the integration efforts, the international engagement has really been very helpful. And I think I certainly will not arrive because we've only been doing this for 1 year, but I think we've really had a good start.
Thank you.
Well, thank you. At least he has proven to everyone that he's had an easier ride than I'm about to have. Well, and essentially the point comes down to they've moved from the more technical and precise area to the more intense and less predictable area. And you would think that that would mean a bumpier ride. But in reality, moving to something quite technical and very precise is relatively bumpier in many respects. The one thing that I think is somewhat helpful is I haven't been at the Consumer Protection Council that long. It's just under 2 years, and then you get this graveyard shift. But what I think has been helpful is that the way the statute was set up before was relatively broad, and so I think there was a particular provision that literally addressed what was considered obnoxious practices in the market or whatever was exploitative of consumers. And so there was no way to broadly interpret that without running into conduct that would be considered anti-competitive. And so in some sense, we already have, dipped our feet in the mud somewhat. And because the law itself was very long time coming, you had an agency that was somewhat salivating and prepared for it. But that's the one thing. But the reality of waking up the next day and then looking in the mirror and finding something entirely different has struck us. One thing that we recommended and thought would be in the law was a transition period. It turns out that the law that came out didn't have that transition period. And so we literally had to wake up the next morning and start figuring many things out. Industry is more concerned in the sense that people have done their businesses in a way that is not necessarily illegal, and then all of a sudden there are laws that suggest that that's prohibited. So there is a lack of capacity, both from the regulator's side and many times even from industry's side, whether lawyers or competition economists. And so that's an advantage. At least nobody seems to be far ahead of the other person, where the real definition of the bliss in ignorance, where no one is ahead of the other person. But the relationships we have are obviously have become one of our most important assets, both domestically and internationally. We had a Securities and Exchange Commission that was already looking at some major work from a fairness standpoint. And so all that, the new law repealed those provisions in their law. And so at least the law may have repealed the provisions, but at least it didn't take away the knowledge. And so the knowledge of those folks in the Securities and Exchange Commission is becoming very important. The FTC is another example. And FTC, luckily, is also an organization that does both things. And so we have relationships within the FTC that can help both ways. And obviously, being at the African dialogue with other consumer protection authorities who also do competition work has been very helpful. And then somehow, after I came to the spring meeting last year, I met UNCTAD and ended up speaking in Geneva later in the year, and that helped with the relationship. And so do I have everything I need? No, but do I know whose doors to knock on? Yeah, I do. And so I suppose instead of sleeping with both eyes open, I sleep with one eye closed.
All right, excellent way to pass. Commissioner Wong, I don't know how many eyes you sleep with, open or closed, but if you want to comment on Singapore or Nigeria's comments, we would welcome.
Yes, in Hong Kong, the people of Hong Kong has been enjoying the protection or the consumer protection for more than 40 years. It's one of the longest authorities in Hong Kong, protecting the interests of the public. People in Hong Kong don't realize that they have privacy effectively protected by my office until recently. Because of the cross-border incidents, and they were woken up, by those impact not only on their own personal data but on the economy as a whole. And the competition authority has not come into place until I think a couple of years ago. But the three persons in charge of these authorities, put their heads together recently, and we try to work out, some sort of a cooperation, saving, resources and sharing information, and this is agreeable. But we have different portfolios, we have different legislative frameworks, and different responsibilities. So it's still some way to go before we can reach some sort of enforcement agreements and so on. But we managed to cooperate with our counterparts, if there are any, in the mainland of China or in the neighboring emerging economies. In the mainland of China, they do have a very strong regime protecting consumers' interest. They have consumers' protection authorities, very effective, given the number of people affected in the mainland. So, we do envy that. The consumers' interests are protected well in the mainland of China. Privacy rights recently they have been catching up very fast. They know how serious the issue could be. And just a couple of days ago, as reported by I think it's CNN. I don't know whether it's real news or fake news. But they talk about China has been will lose up to 5.5 trillion US dollars in economic growth if they don't brush up their privacy protection law. So that's a very serious warning. In fact, they have been doing something, and we have been liaising and sharing our experience with the mainland Chinese authorities recently. With the neighboring regions like Macau, our another special administrative region, we are talking about entering into some sort of an MOU, and we are wrapping up our MOU with Singapore. We have drawn up MOU agreements with Korea. So we do plan to enter into cooperation agreements, including sharing of information where appropriate amongst economies and regions in Asia, in particular.
Thank you. I'll quickly pass over to Liz.
I was going to say one of the interesting themes that I think everyone has hit on in that last question is one of relationship building as one of the most important assets. And we touched in the introductions on developing relations through MOUs, through regional and multilateral fora. So I thought I'd like to hear from Reiner, if he's still awake and up down there, and see what you might have to say on those points.
Both eyes wide open. If you allow me, I just come back 1 second on your previous question on domestic priorities and influencing the international agenda. I just wanted to add, and I owe that to my colleagues, that having the GDPR in place now for almost 1 year, we see that this actually really heavily influences our international outreach, not only in promoting privacy legislation in other countries, but also to cooperate in terms of enforcement when it comes to privacy violations. But if you look at the multilateral fora and our cooperation there, I already mentioned our work in the ECN, in the ICN, and in the OECD. Certainly many of the features that we have in the ECN, taking that we enforce the same law, are not transposable to the wider multilateral framework, but I think they can still inspire and they can still help also to set the agenda for these discussions. We have features in the ECN which foresee that if member states want to take antitrust decisions, that they have to notify that to us so that we can see the decisions before actually they are adopted. We have established an early warning system amongst authorities so that if somebody wants to take up a new investigation, a new type of investigation, he would notify that to the other members of the ECN. And we even share all our own decisions before we adopt them through the advisory committees with the member states. But much more important is, I think, the exchange that we see in the working groups in the ECN. We have working groups on each and every topic and in different sectors. So you actually have the people that work on the cases. They come together and say, we work on this and this cartel or vertical agreement. If we work on forensic IT or in pharmaceuticals, transport or financial sectors, they sit together, discuss their cases and exchange and see whether there are lessons to be learned. And these kind of discussions certainly feed into our international engagement also then in the ICN and in the OECD. In the ICN, if you look, we are co-chairing the cartel working group there, but we also are very active in all the other working groups. I think most importantly, we are in the steering committee and similarly also in the OECD. We try actually to set the agenda forward-looking to identify the topics that will be the enforcement problems of the future and sit together and want to address them already as soon as possible.
Thank you. The work in the regional area of the European Competition Network, the ECN, is particularly informative for us. And I think I might turn to Paula, because I know you've been quite active in both regional and multilateral fora. Maybe you want to pick up on some of those points.
Yeah, I was actually taking notes here while Rainer was talking about how we can learn from that and bring that to our regional group. But I think maybe what I can share is a little bit about not so much our regional cooperation, but our BRICS cooperation, which I think is an interesting kind of cooperation because we're largely very different countries, even though we're all in this kind of same economic development stage, and it's curious. It's curious that prior to our memorandums of understanding, we didn't truly cooperate. So this is a case where the MOUs didn't really cement an existing relationship, as in with most countries, but it truly fostered a relationship, and this relationship has been very fruitful. I mean, we get together every 2 years officially, even though we do also interact and very meaningfully in when we see each other at the OECD, when we see each other at the spring meeting. We have a spring meeting of the Brazilian Bar, which happens every year in October in Brazil. And last year, BRICS countries were also invited to our spring meeting, and they attended, and we had a closed session at our spring meeting, and then we had an open session with the bar. And this kind of cooperation has been extremely important in order to foster not only our own agenda, and but also to be able to kind of set the tone for the international agenda and what are the issues that we as developing economies and transitioning economies believe are most important at this time. And one of the issues that the BRICS countries have been working on and is proving to be very useful is on digital economies. So we have a digital economy working group that gets together once a year. And I was actually taking notes here on Rainer's talking about the working groups because, and also I think the human glue issue is truly central because this is what works. And our experience in international cooperation is that what really proves and what really brings more knowledge to Kaji is having the people that are working on the cases meet with the people that are working on the cases in other jurisdictions. So for the digital economy working group, for example, that we have at BRICS, we have people from our economics department, from our superintendents, from the commission, and we're not talking about high-level employees. We're talking about the actual technical staff, and this is extremely important. And we've also been doing a lot of exchange programs, and this is not only within BRICS, but with other agencies. So we've actually just had a member of the FTC in Brazil for the past 3 months, and we hope that this continues because it was extremely useful for us and extremely helpful to have someone there to help us in our day-to-day issues and really just have someone there to be able to consult with. And we do this not only by having someone there, but we've also sent someone from our staff to other agencies, and we've done this regionally in Latin America. So I think the regional cooperation, while for a country like Brazil, when you think of regional cooperation, we think of Latin America, but for Brazil specifically speaking, it's not so much Latin America, but regional for us would be Latin America plus BRICS, I think.
Chris, before we move on to our next topic, did you want to respond to any of this?
Well, I was just going to briefly make one point, if I may. We heard a few minutes ago a lot about the cooperation between the competition and consumer side in terms of procedure and substantive and process and so on. But I think it's important to think about bringing those sides together at a substantive law level as well. So for the CMA being a joint competition and consumer authority, we naturally, when presented with a new difficult issue, we naturally think about it from both sides of the coin. And I think that's important that we try and replicate that on a sort of a international dimension. So one particularly useful in terms of digital economy issues as well. So one example I'd like to draw on is some work we've been doing on personalised pricing. It's been causing a fair bit of debate in the UK, and we naturally thought about it from the competition and consumer side, thinking about where the problems and where the harm might arise and where it might most effectively be tackled. And so what we did is we took the a policy paper to OECD, both to the consumer panel but also to the competition panel. So we had separate discussions there, getting different perspectives. We also encourage the two committees to discuss it collectively. And I think we've found that really useful, really illustrative, and I think it's always good to bring different sides of the debate together to really understand. I talked about common ground a little while ago, and I think it's surprising how much common ground can be identified when you're bringing the debate together.
Thanks, Chris. Okay, on your point of common ground, we want to go to something that's very difficult to do. During our conversations, you all shared with us really that there are some frustrations, and we get down to it, what hasn't worked well is something that we also want to put on the table. We're not afraid. We want to bring it to you, but we are running out of time, so don't think it's because we're afraid, but so we're going to ask you to move quickly. So we're going to go over to you, Commissioner Wong. Can you talk to us in just a we're going to time you too. Quickly, what hasn't worked well? And you'll have a chance to put more on the record, but we really do want to hear because we want to get it right and we want to improve. That's why we're here.
Yeah. What hasn't worked well, perhaps you may term them as difficulties or challenges. In my view, there are more than a couple of them, including domestic legal restrictions, legal systems, the government influence or institutionalized design, the security issues or the communications issues, no free flow of information in some jurisdictions, no free flow of data or data localization in some jurisdictions. And most important of all, in my view, as a lawyer, lawyers tend to overclassify or misclassify the meaning of confidential information.
Wow,
Okay.
That's powerful. Okay.
Because as a regulator, and I always come across lawyers, banning, the placard saying that it's confidential. You can't review it to anybody else. And I said, I'm a regulator. I'm investigating your client's case. And so, okay, right. Now you asked me to keep quiet.
Well, we're going to come back to you. We're not asking you to keep quiet, but we're going to come back to you and let you get a chance to get in more on that. Tunde, what hasn't worked well?
Well, I think Commissioner Wong has he spoke for everyone. Yeah, except, of course, I'm a lawyer. And so, but yeah, the big challenge continues to be information sharing. And there's a platform that's working, but whether we can get to the point where we can truly, fully, really optimize. And I think everything works into that. If you see where we started about domestic priorities. And so the information sharing would take on the shape or the character of what the domestic priorities are. I think the platforms for accessing information seem robust and good, but the specifics that sometimes are very critical seem to present quite a potential challenge, sometimes because of local legislation, again because of priorities. And so you might have a regulator who doesn't have the kind of information you're looking for, because what's a big problem to you is not a big problem in that environment. And then you think about what it will cost them to start looking for that information when they don't have a need to pursue it. But I think that to the extent that we can find a way to still simplify that whole information sharing process to get around the data protection issues, I think that that would be a very important thing. And I might note that in a previous investigation once, then I was outside counsel and I was assisting the Civil Aviation Authority into what might be collusion between two airlines on a certain route. And when they asked for information, and both airlines were in Europe, and the European data protection laws prohibited transfer of information that is domiciled.
You said no fighting on the panel, Tunde. I see Rainey, you're getting ready to jump in.
Okay. But essentially what it was exactly the point he made, that the exception to exchange of laws need to be the fact that it's a regulatory activity.
All right. Paula, I'm failing in my job, though, guys. It's very hard with all these compelling comments to cut you off, so please self-regulate.
I'll be very fast. What hasn't worked in Brazil is something that hasn't worked for a very long time, which is basically service of process. So when we have mainly cartel investigations and we have to serve companies or individuals outside of Brazil, and for certain countries, especially countries with information privacy laws, it's very difficult to complete service of process in these countries. And it'll sometimes take us 5 years, 6 years, 7 years to complete service of process. And the problem in Brazil is that all defendants in a case have to be served before the case can actually begin. So what happens is either the case is on pause for, maybe 5 years, or what we have to eventually do is after a number of years, we have to remove certain individuals from this case and open a separate case for them so that we can move on with the investigation, because otherwise we have a cartel investigation that begins 7 years after we initiate the case, and the case is usually initiated maybe 5 years after the conduct is discovered, and so that's maybe 10 or 15 years after the fact, and that's already way too late. So what we truly need to find a way to move forward with this is how to serve process.
I think that's a problem we all share. I actually want to move quickly from kind of case cooperation difficulties to policy cooperation or policy issues. And maybe I'll just tag team both Reiner and Han Lee and see if you'd like to just have a quick interjection on issues you're seeing.
You go first. Okay, thanks. I think I want to speak on the regional level at Southeast Asia, and I suppose we're to talk about the EU level. I think the challenge is sometimes the member states' domestic political considerations overshadow some of the regional considerations. So, to give a concrete example, in ASEAN, one member state does not have merger provisions for political considerations. I know Hong Kong as well didn't pass the merger law because, again, I think it was political considerations. So I think these are impediments. And then another competition authority in our region is trying to pass leniency provisions, and that would greatly facilitate cooperation. But again, I think the domestic politics is getting in the way. I think a positive example is in the case of Thailand, where they exempted state-owned enterprises from competition law for a long time, but since last year that's been brought in. So that's a positive example of how it's worked out. But I think sometimes these do get in the way of regional integration efforts.
Reiner?
Thank you. Well, as I said before, I think we have managed to overcome some of the problems of cultural differences, speaking the same language, which doesn't mean that it's always easy to overcome also structural differences. And I think what we see is we have different concepts. We have different concepts of state. As Stephen already mentioned, we have different legal systems. We see, for example, when we look to China, they have a different, when we make our merger assessments, they have a different concept of state-owned enterprises. We experience that very, very closely just now when it comes to our second generation agreements, actually. As you know, for us, privacy is a very high good. It's protected as a constitutional right. So when we want to enter in these kind of really far-reaching agreements with third partners, we have to make sure that when we exchange evidence, actually, then on the ground, that the protection of the data of the persons, the data subjects concerned, is actually also protected once it is passed over to the other authorities, and that there is a sufficient redress mechanism in place. Other systems or systemic differences are very difficult to overcome. Again, when we think about, we run an administrative system, others have criminal systems, and for us it is a problem if evidence that we hand over to a third country authority is used in their criminal proceedings. So these systemic issues, I don't want to say are impossible to solve, but will take a bit longer, perhaps.
Well, speaking of solving, we're kind of more on the optimistic side of the camp here and don't want to end on negativity. So we thought maybe if we'd open up for about 2 or 3 minutes to see if you have any suggestions in addition to those just made by Reiner, but to overcoming some of these issues or impediments. And since we skipped over Chris, I thought maybe I would just give you the floor for a minute.
Thank you. So I think it's maybe moving on to something we're going to talk about, but I think a really effective way of coming over some of these difficulties is actually learning through doing and actually cooperating and doing some joint working. Because I think sometimes it's quite difficult to really process some of the difficulties in the abstract. And it's sometimes only when you're faced with a particular problem you can work out the solution and the way around it. And I think something that we do, we've been involved in both at the European and also an international consumer enforcement level, is sort of undertaking something we call sweeps, where we sort of take a case from kind of cradle to grave, as it were, starting off sort of identifying a potential issue that might be there, that we go away and investigate, we bring back the results together, and then we work out how we can take action together and what kind of action that could be like. What that could look like. And through that, taking those different stages of the case together, you identify potential differences, you identify the common ground, you identify the solutions, and it can be a really fertile ground for working together and sharing knowledge and developing kind of new practices and so on. And it can work really effectively, I think.
Thank you. That is a perfect segue to something that one of our colleagues from the audience raised, something that we had discussed among ourselves. What kind of cooperation or collaboration do you have with emerging markets, emerging competition, consumer protection, privacy authorities? Put differently, what kind of relationships are you exploring between younger and more mature agencies? Why don't we go first to you, Hanli?
I think it's two-way. I think certainly within ASEAN, we're doing a lot of capacity building, and we have a lot of partners. I mentioned the Australia and New Zealand CLIP program, but we also have the Japan ASEAN Integration Fund, the GIZ. It's a very long German word which I can't pronounce, so I'll just call it GIZ.
Me either, by the way.
It's a German technical assistance program. And also the Europeans have come in last year, and so have the Canadians. So still waiting for the Americans, actually. So, but
Hey, Jan was already there. Come on.
okay. But I think all these partners have really been useful for capacity building, and they're actual, like I mentioned earlier, staff exchanges, placements, both ways. From more experienced agency to a newer agency to more experience, and as well as workshops and all the like. So I think it's really a very fruitful two-way exchange, and there's always something to learn.
Thank you very much. Stephen.
Yes. We have experienced liaising or sharing experience with the younger economies, including those in the mainland China, because they don't have a similar framework as we do, or as the EU does, or the Americans have in their own jurisdictions. So, but the issue of privacy, for example, data privacy, has become so prevalent as a topic for discussion, not only amongst the organizations themselves, because of the heavy fines they are being threatened, but also amongst the citizens in the mainland. So, but they lack the requisite trust. If they talk about this, they fear that we are trying to influence, our line of thinking, which is culturally different in relation to the protection as a basic or fundamental human right. So this is a cultural difference, and the same happens in other emerging economies. In that, because they might misunderstand that we have, some hidden agenda, political ones included, and so on. So probably I would suggest that in order to pave a way, the right way or the right track, for all the economies and emerging, young or otherwise, within the region. We could set up, help set up, a multinational or multi-jurisdictional database, for example, or some sort of a repository of, the best practices in the related fields. In the longer run, perhaps, when we aim to reach, some sort of a model arrangement, model agreement, model clauses, be drafted and shared, introduced for the regional cooperation, whether multilateral or bilateral enforcement network or management. At the end of the day, perhaps, like, ASEAN, APAC, and the EU, we might, wish to come to some sort of multinational treaty on which the economies can join and have reference to.
Thank you. It harkens back to the panel yesterday to IASCO, maybe looking at an MOU, amongst other things. Tunde, can you share with us in a 1-minute response, new or younger, before we wrap up with the last question?
Well, we're pretty young, so...
No pressure, no pressure.
The relationship, obviously, with the FTC has been very helpful, and we're using two things with respect to the competition side, the strong relationships we've had on the consumer protection side, and the relationship the FTC had with the Securities and Exchange Commission in Nigeria. In the Consumer Protection Council, I inherited a long relationship between the FTC and the Council, including especially with respect to regional capacity development and specific bilateral capacity development in the FTC's fellowship program. And that has been very helpful. The European Union, they provided quite some support in developing the legislation. And so that's also a channel that we look to depend on. So yes, there are quite some relationships. And then obviously relationships that are just a conversational, like with UNCTAD and a few others. So I'm relatively comfortable with what I think is going to be a great network of support from more experienced, mature organizations.
Thank you. Well done.
Well, because we are so interested in learning from our experts, and after this extremely fruitful discussion, I wanted to give each of you at least a minute or so to just provide any ideas you might have on how we might best develop the FTC's tools and international program for the success of our international outreach, but also I think our global initiative for good enforcement. So maybe we can just move down the line, starting with Paula.
Thanks, Liz. Well, first of all, I'd like to commend the FTC on your efforts on international cooperation. I think the international cooperation that the FTC has with Brazil has been not only very intense. We've had people here. You've sent people there. We've had a lot of pick up the phone cooperation. Talks about cases and that's been extremely helpful. But what we would like to see, and I think this is something that we would like to see not only with the FTC but with other jurisdictions as well, is a possibility of exchanging more information and maybe more confidential information on specific cases. So with the U.S., I know that Brazil has an MLAT, but it covers basically criminal investigations. So that's not something that we can exchange with the FTC. And the FTC has a lot more experience in Brazil on unilateral conduct, abusive dominance, and that's something that CAGI has been focusing on over the past few years, and it's new to us. And so having the experience of the FTC, especially because a lot of our cases are also cases that the FTC has gone through. So that would be very interesting for us.
For us too, trust me. Tunde.
Thank you very much, and I completely agree with Paula. I think the FTC is doing quite a phenomenal job, truly investing in other agencies, and the work you're doing to actually maintain those relationships is amazing. Because two things that come to mind when I think about the FTC: you can resort to them, and they're a resource. And so that's very important. The one thing that I might add, in addition to the information sharing, which is quite perennial, as it were, is that they shouldn't substitute a bilateral engagement with a country for a regional engagement where that country also belongs. I think engaging on those two levels are so important, because now you can see, I mean, I'm using West Africa as an example. We've got ECOWAS, we've got Nigeria, and now we've got the African Continental Free Trade Agreement coming up. I think it's good to engage on the regional level, but have certain level of flexibility to also recognize what the national priorities are, so you can engage on that level also. I think with that, you're probably going to cover the entire space. Thank you.
Thank you. It's an excellent thought. Han Li.
Yeah. I think we've always recognized, I think, the FTC's leadership role in international organizations like Asean and OECD. We are also beginning to see FTC or the US taking a bigger interest in our region. This Friday, there's a panel on Asean at spring meeting, and I think no doubt coordinated by FTC, and I think we look forward to more such partnerships. Just to share, in 2015, in fact, we did a course with the FTC in Singapore on competition, investment, and transparency, together with the US Small Business Administration. That was organized under the Singapore-US Third Country Training Program. So I think we look forward to, again, US leadership in the region.
Thank you. Chris.
So a reflection from me is the Competition and Markets Authority has a wide range of tools, including market-based investigative tools. And we find that having that look across the wider picture, especially on a kind of a no-fault basis, when you're looking at failings of the market rather than failings of individual companies, is a really useful tool and a really useful platform to build on in kind of international discussions. And I think also, on a consumer protection point of view, we have a particular mandate in the UK to focus on issues causing market-wide problems or market-wide practices, and as a result, we're investigating market-wide issues rather than single individual cases. And again, that deepening understanding of the broader picture, I think, is a really valuable kind of asset when you're taking issues and cases on an international arena, and that's something that I think is something worth reflecting on.
Thank you. Rainer.
Thank you. I think I can very much echo what was said before when I told my colleagues in Brussels that I'm going to be on the FTC panel on international cooperation. Everybody said, pay attention what the FTC says. They are the role model for international cooperation, so you can learn a lot from them. And I think that has been certainly true for the past. I would just like to draw attention to a certain kind of bilateral cooperation that we have, that we see that is very fruitful and successful. One of them actually is with Brazil. We have a EU-Brazil sector dialogue. We just had this month in March, 3 colleagues from CAGI coming over to Brussels. That was a very intense and very fruitful dialogue. And we entered into a program which we call a technical cooperation program with Asia, with all Asian countries actually. We have had visitors in this context from Japan, from Korea, from Indonesia, and the Philippines. We haven't had anybody from Singapore yet, and not from Hong Kong yet. But to Hong Kong, actually, we sent one of our former colleagues to your competition enforcement authority, which may do the trick. And finally, what I think is a takeaway is we focus very much on the multilateral cooperation, also on the bilateral cooperation. But what we should not forget is probably that we also raise awareness internally within our organization, that we have these capabilities, that we do all this, because actually it is the people working on the ground on the cases. They have to spot that there is an international dimension to their case, and they have to know how to react, how to bring this forward, and how to actually then exchange it with other authorities, because we might have the best cooperation in the world. If people working on the cases don't realize that, then it doesn't help.
Super point. And Commissioner Wang.
Yeah, very quickly, as a regulatory authority enforcing the law, the relevant law, in our regard, this is about personal data privacy law. We must emphasize that the enforcement must be fair. In this regard, we need accurate information and intelligence, facts especially. So in view of the cross-border nature of data incidents, for example, you can name a few, and also the absence of unifying enforcement laws and practices, effectively, some of the organizations might find shelter, because of the absence, because of the lack of the unifying enforcement laws and practices for those who, for example, misuse or abuse data that doesn't belong to them. So it is in this era, digital economy, it's very difficult, to comply with the legal requirements if we have restrictions about cross-border transfer, localization, or consent-based system of transfer. So what we need, is international engagement, effective international engagement, and thankfully, FTC has played a leading or a pivotal role, over the last few years, and bearing also in mind that the USA, EU are the top two or top three trading partners of Hong Kong. And so we have a lot of connections with the Americans, and especially in the field of data incidents. So we need, apart from being an enforcer, we as regulators should also play the role of a facilitator. We should facilitate the innovation and economic growth without compromising the privacy right enjoyed by the citizens, streamline the businesses, reduce implementation cost, deliver compliance efficiency, and support the continued growth of the digital ecosystem and effective law enforcement and beneficial use of data. Now, as I mentioned earlier on, as part of China, but with a very different legal system, including a unique data protection framework. Hong Kong has the unique and irreplaceable attributes of being part of China in respect of, one, the free flow of information.
Thank you so much, Commissioner. Well, with that, we're going to conclude this panel. We want to thank you very much. We've left some questions on the table. We'll deliver them to Randy. Maybe he knows all the answers anyway. We're going to take a brief 15-minute break and invite those speakers who are on the next session to please come forward. Also, in other announcements, 2 silver rings found. Collect them at the table outside. And thank you all very much for a super awesome, successful, phenomenal panel.
All right. So tomorrow we talk in detail.
Yes. We're complete. Ready to go? Welcome back from the break. If everybody would please take their seats, we're ready to proceed to our last session. Again, I'm Randy Treitel from the Office of International Affairs, and we are now approaching the end of our 2 days of hearings, and we'll conclude with the panel on the FTC's role in a changing world. As the title indicates, this panel will focus on the future, anticipating the challenges that the FTC will face, and seeking insights and guidance from leading experts from the realms of data privacy, consumer protection, and competition policy. To lead us into our panel, there is no better person to do that than one of the true greats of the antitrust field, domestically and internationally. That is Jim Rill. I have had the pleasure and privilege of knowing Jim for several decades, and I would have been honored to introduce him to you properly, but as you will see, I'm about to yield the floor to someone who knows Jim even longer and better than I. Ladies and gentlemen, from the FTC's Office of Congressional Relations, Derek Rill.
Oh my God.
Thank you, Randy, for this absolute honor to introduce Jim Rill for our next session titled The FTC's Role in a Changing World. Mr. Rill has an impressive resume, to say the least. Summarizing his accomplishments is quite the challenge. But I'll be brief, as I'm told his introduction counts towards his speaker time. You wouldn't forgive me if I didn't give him enough time to be able to talk. So quickly, here are some of his career bullet points. Currently senior counsel at Baker Botts, Mr. Rill served from 1989 to 1992 as Assistant Attorney General in charge of the Antitrust Division, where he negotiated the U.S. EC Antitrust Cooperation Agreement. Issued in 1992, the first joint FTC and DOJ horizontal merger guidelines, and again provided counsel for the revision of those guidelines in 2010. He led the International Competition Policy Advisory Committee, which spawned the ICN. Now, 130 member nations can trace their roots to the man Randy Treitel called the godfather of the ICN. As for awards, in 2012, Mr. Rill received DOJ's, and I quote, highest antitrust honor, the Sherman Award, for his outstanding lifetime contributions to the protection of American consumers and the preservation of economic liberty, end quote. Lastly, recognizing Mr. Rill's passion for helping grow talented, aspiring antitrust attorneys, DOJ a few years ago launched the Rill Fellowship, which entails a 24-month appointment at DOJ for the next generation of antitrust superstars, who, like many of Mr. Rill's current protégés, probably will end up as DOJ antitrust chiefs or commissioners here at the FTC. You know, as incredible as all that iconic stuff, mentioned is what makes Mr. Rill so very special is that he also found time to be as wonderful and loving father as you'd ever meet. Please welcome, as Randy calls him, the Dean of the U.S. Antitrust Bar, my dad, Jim Rill.
Well, that leaves me speechless, which I'm not known for being. Derek, thank you very much. And Randy, you blindsided me. I want to talk in what time is left for really what I see as the challenges in front of the FTC and indeed in front of the agencies of the federal government in international cooperation and international enforcement, to lay the groundwork for the panel that follows and to give some humble, if somewhat, I would say, radical suggestions for going forward. I'd like to talk about really in order of policy and substantive contributions that the Commission has made in organizational and international organizations, about technical assistance programs to newly emerging agencies, particularly in regard to the rise of new technology, to the promotion of accountability in international cooperation. It's one thing to have guidance, it's another thing to be sure it's followed. And then finally, I'd like to talk not only about international cooperation, but domestic cooperation. I think a challenge and something that's vitally needed in the 21st century. We don't know where we can go unless we know where we've been. As the saying on the front of the archives building indicates, you all hear me all right? Fighting an allergy and my voice isn't as resonant as it usually is, but in front of the archives building there's the podium with the platform, "The past is history." And in this particular case of international cooperation and the work of the FTC, the past is indeed history. The role of the FTC in international cooperation really cannot be overemphasized. The work that the Commission's done in Asean and OECD, providing, I think, a remarkable set, for example, of antitrust enforcement guidelines on policy, procedure, transparency, and engagement, is a real contribution to international cooperation. That was adopted by the ASEAN and has been since updated and improved and annotated. Other guidance documents, too numerous to be mentioned, follow in the merger field and the unilateral conduct field and other areas, largely, if not exclusively, but largely fomented by, promoted by the work of the Federal Trade Commission. Technical assistance. The technical assistance provided by the Federal Trade Commission and the United States Department of Justice goes all the way back to 1990 and possibly before. In 1990, as the Soviet Union collapsed, the countries of Eastern Europe threw off the bonds. Federal Trade Commission and the Department of Justice sent missions, often joint missions, to places like Budapest, Prague, Warsaw, and other cities around the newly emerging free market systems of Central and Eastern Europe. That predated the work that the FTC has done since that time. In 2017 alone, the FTC had a program of conducting 38 programs of technical assistance in 22 jurisdictions. I won't name them all, but 38 programs in 22 jurisdictions of technical assistance. Cooperative agreement. In 2018, the International Antitrust Report, authored by Randy Treitel, the FTC, DOJ, and DOJ play an active role in U.S. delegations that negotiate competition chapters in proposed trade agreements. Highlighted among those agreements, of course, are the new antitrust chapter in the I guess call it NAFTA 2.0, in which the parties agree to foundational principles of process requiring transparency, early consultation, access to information, an opportunity to appear before the agency, and the right to judicial review. Should that agreement be adopted, be confirmed by the Senate, it would be a landmark agreement on antitrust cooperation and a trade agreement. The Chorus Agreement contains a competition chapter which just the other day has been invoked by USTR calling for consultation with the Korean Antitrust Agency on the ability to obtain evidence and appeal. Consider that evidence and rebut it. We'll see where that goes. So that's the very, very impressive history that's been fomented by the Federal Trade Commission. But what about looking forward? And let me, with great respect and some hesitancy, to make some suggestions. First of all, seems to me appropriate to continue the work that's being done with the international organizations to promote sound principles of consumer welfare-based antitrust principles. Much of the focus now has been on procedural reform, as it should be. Let's take a look at what can be done on consultation that leads to substantive coordination and addresses the issues of the proper effect that antitrust should have on the economy. A little bit of evangelical work here is necessary. How far it goes, I don't know, but we should not ignore the need to, if you will, evangelize on substance in discussions, negotiations, in international organizations and bilateral basis. The link between intellectual property and antitrust isn't a bad place to start. A focus can be made on non-economic goals in certain nations and the influence of state-owned as well as state-supported enterprises. In 2017, the U.S. Chamber put together a group of, let's say, so-called experts. I was on it, so that's why I say so-called, which issued a report which suggested that the ICN form a working group that focuses on state-owned enterprises and state-supported enterprises. Why not a joint FTC-DOJ effort in that direction? National champions are again on top of the mind, given the recent decision of the EC, for example, to block the Siemens-Alstom merger and the objections thereto by the French and German governments. Why not address that issue? Again, procedure is important, procedure is critically important, but you can have the best trial in the world if they hang you for the wrong offense. And it seems to me that substance is a very legitimate area for this kind of work. Continue the technical assistance programs. I don't think I need to I think I'm singing to the choir when I say that. But consider also doing that jointly with the Department of Justice. We started out in 1990 doing it jointly. It seemed to work then. Why not give it another try and work jointly with the different but excellent skills brought in from both of the agencies? I would say convert these guidance documents into best practice documents. Through the ICN, particularly OECD issued best practice documents, so did the ICN and merger notification and procedure. Why not broaden that, at least to put more gravitas, if you will, substance behind the guidance documents? And then I would say continue workshops and roundtables. I think the FTC's workshops and roundtables in the ICN area have been paragons of value. More is not a bad idea. Again, focusing on substance. Guidance is very well and good, but are people actually following the guidance? Our nations, our agencies following the guidance? We all know too often that in OECD or an ICN, a question is asked, do you give transparency? Oh yeah, next question. What about some system of measuring accountability? Radical consideration perhaps, but I think this would have been the initial thought, maybe still the thought, behind the Department of Justice initiative for the multilateral framework for procedure, which now apparently is going on a dual track, side-by-side track, with the ICN, according to recent speech by Roger Alford. This is a DOJ initiative, but it's one I think that the FTC can play a role in through the ICN or support for the MFP. The agencies should work together to formulate, develop a system for measuring accountability and adherence to the guidance documents, which hopefully would become best practice documents. Probably have to start on a voluntary basis, probably have to have a company sign on to it, but it's worth exploring, and worth exploring, I suggest to you, jointly. I'm not suggesting any sanction system. I'm not suggesting trade, God help us, trade sanctions. All I can think of in those days, back in the day when you traded off chicken for brandy, which way in the past I consider that a personal offense. But as has been said by a lot of people, and I think has a good bit of truth to it, reputational effect can be very significant. And holding out an agency for, if I would say, gross departure from globally accepted norms of procedural or substantive agreement principles can have a reputational effect. Let me switch for a minute to another form of cooperation, and that's interagency cooperation. I suggest that there's a lot of room for cooperation between the two antitrust agencies. The 2017 guidelines on international enforcement, international cooperation, were jointly issued by DOJ and FTC. The suggestion in there that applies to what the agencies do, not to what one agency does or what the other agency does, but what the agencies do. Specifically, one of the provisions is they may engage in general discussions with foreign authorities on matters where only one authority, that is the foreign authority, has an open investigation. Why not have both deal with that issue? The guidelines uses the word plural agencies. This is consistent with a recent speech, 2013, that's recent in my vocabulary, article on antitrust source, which I recommend to you by then Commissioner Olhausen. So why not, for example, a joint work program in the international sector in addition to the joint technical assistance, which has worked so well in the past? And what about it? What about cooperation and coordination with the other non-antitrust agencies of the federal government? I recognize that this can bring in other, from a domestic standpoint, what seem to be foreign ideas, ideas that antitrust is not particularly comfortable with. I went through 3 years of working with the USTR and the Structural Impediment Initiative talks with the Japanese. I understand some of the problems of that relationship. But these agencies, they have a good bit to offer in many respects. Their expertise in particular industries is very valuable, can be very instructive, can be very useful. They can bring into play and bring into understanding issues of national interest that are sometimes beyond the antitrust agencies, at least professional focus. National security being, I think, paramount among those issues, where the antitrust agencies can cooperate with these other agencies. Now, the Chamber report that I mentioned to you suggested a cabinet-level committee to deal with antitrust policy. I frankly don't think that's a great idea. But I think the antitrust agencies themselves can informally call together as needed and listen to and reflect on the, I'm getting the flash that the time's up, I'm almost through, that can bring the expertise and considerations which can well inform the antitrust decisions that are being made by the antitrust agencies, which can have a ramification across technological issues affecting industries with which the Commission and the DOJ might well be unfamiliar, and national security interests which can be vital to the welfare of the country. Whatever as decisions are being made on antitrust that affect antitrust, the DOJ and the Commission should have a seat at the table to explore conversely, the antitrust implications of industry decisions being made at another level. And the Commission, although not as part of the executive branch, the Commission can bring a good bit to play in the way of its expertise to those considerations, so it should have the seat at the table. So there's the issue of international cooperation, which we've addressed, and I would suggest to you equally important in the international field is the issue of cooperation across the panoply of the federal government, including our sister agency, my alma mater, the Department of Justice, and the other agencies of the federal government that have a particular expertise and have much to offer in those areas that can affect, influence, and promote sound antitrust enforcement. So with that, thank you very much for your time. I appreciate it and look forward to hearing the panel.
Thanks so much, Jim. Let's bring the last panel up to the table. Thank you. Good. Well, thanks again to Jim Rill for his, as always, insightful and thought-provoking remarks, which will help frame our discussion and will also inform our thinking about how the FTC should advance our international antitrust agenda. Now, we're going to organize this panel, or try to organize the discussion into 4 parts, recognizing that the borders between them are going to be somewhat porous. First, we're going to ask for some thoughts on what makes for an effective competition, consumer protection, and/or data privacy agency. We'll then consider how the FTC can be most effective in its bilateral relationships and cooperation. Next, we'll take up the FTC's role in promoting sound policy and, as appropriate, as referred to in the previous panel, policy convergence. And we'll conclude with perspectives on the role of the FTC as a leader in thought and action in our fields. We'll leave around 10 minutes for questions, so please use the question cards that will be circulating. And we'll try to leave a few last minutes for closing thoughts. All of our previous sessions have raised many questions on our panel. We'll try to find at least some of the answers. To do that, we have an absolutely world-class, stellar panel, and so we're delighted to be joined by, and I'll do this alphabetically, Bojana Bellamy is the president of Hunt & Andrews Kurth LLP's Center for Information Policy Leadership. Terry Calvani with the Freshfields Law Firm is also former commissioner and acting chairman here at the Federal Trade Commission, where I had the great privilege to be able to work with him, and has an almost unique experience of also having been a member of another international agency, a member of the Irish Competition Authority. Eduardo Perez Mota is senior partner at the SIA Law and Economics firm, and he is the former president of the Mexican Competition Authority, COFECE, and also a former chair of the International Competition Network. Rod Sims is the chairman of the Australian Competition and Consumer Commission. And Andy Wyckoff is the director of the OECD's Directorate for Science, Technology, and Innovation. Let's start with some general principles for a good agency. So to be effective as an enforcer or policy leader, one has to have an institutional structure and institutional principles that undergird the agency. To frame our discussion, I'd first like to turn to Bojana for her thoughts on what makes for an effective agency, especially operating in the international arena. Bojana, I know that your experience is primarily from the privacy world, but from our discussions, I know that your thoughts reflect principles that I think everyone will find relevant to their substantive areas.
Thank you, Randy, very much. I'm delighted to be here. In fact, this whole session is called the FTC Role and Leadership in the Changing World, and the fact that we are having this discussion across a number of experts from different countries and also different areas like competition, consumer, and privacy is really a sign of that leadership. So really, thank you so much for organizing this and, of course, for inviting me as well. We at the CIPL have done a project looking at what constitutes effective regulator in this new world of fourth industrial revolution, of course, from the privacy perspective. The feeling was that we have been advocating for a very long time for need for accountable, corporately, digitally responsible organizations on one side, and then we were thinking, so what does the world look like from the side of regulators in this new innovative world with disruption, technology that is bringing exciting innovation every day? How can regulators really step up and be effective? The work very much resonates with what I have actually heard this morning, Randy, your fantastic panel on this, on the comparative legal traditions, and Professor Bignoni, I think, and Marsden have talked a little bit about that. So what we have found is that to be effective regulators really need to step up and be strategic, prioritize their engagement, thought leadership, action versus potential enforcement, and be very transparent in how they conduct their regulatory policy, very much risk-based as well. So selective to be effective was a great wording that was said actually by former Information Commissioner Richard Thomas. The second point is that constructive engagement should be favored over the enforcement, and enforcement should be used, of course, for those who deliberately, repeatedly keep breaking the rules and not wanting to engage with this new regulator. But this constructive engagement, of course, requires some innovative thinking, innovative regulatory policy. And so we looked at things like, for example, regulatory sandbox, which first started with the Financial Service Authority in the UK, but has been now picked up by the UK Information Commissioner as well as Singapore Commissioner, and kind of thinking this is an example of this, how the constructive engagement can be formalized in a more formal way, right? But of course, it is important that constructive engagement is a tango, right? You can't just have an effective regulator, you have to have an accountable organization who is ready to engage with regulators. So this is really what we felt was really needed in this new world. Now, final point is that effective and new regulator has to also build bridges with other regulators internationally, and I know we will be talking more about this. Our final point of our research work was relating to the incentives. And we felt that effective and smart regulators should be incentivizing, rewarding those organizations that step up and are able to deliver compliance in a new way and go beyond compliance. And I think it would be really interesting to discuss what could these incentives look like. I think we've seen some in the past from FTC. So as I'm speaking about this, I'm kind of thinking FTC was pretty much there with this. But of course, this isn't just about FTC. It's about other data protection regulators that operate globally in this connected world, and they're increasingly having to cooperate. So our message was very much not just for FTC, it was for all the other regulators really stepping up in this new world.
So that's getting us off to a great start, Bojana, and I'd be interested in others' reactions to those points, and also turning it back to the FTC. What can we learn from the experience of other jurisdictions in this area, and how can we apply that to our work? Let me first ask Eduardo, based on your experience, both with the Mexican agency and in your interactions with agencies around the world through the ICN.
Thank you, Randy, and thank you for this invitation. If you allow me, I consider that there are 5 elements that basically characterize a good, a well-designed, let's put it that way, a well-designed agency in competition. First, it has to be independent. It has to be independent from the executive branch, from the government, what is that is part of it, but it has to be independent because its only obligation is to apply the law. They do not design the law. The design of the law is part of the government of government and the legislative consideration and jurisdiction. Obviously, the concept of independency goes hand by hand with the specific characteristics of the jurisdiction. I remember having this discussion in an OECD table some few years ago with some colleagues from Denmark, and they were saying, well, I mean, why are you insisting so much in the independency? We are not having that problem. We have never faced that problem with the executive branch. They have always respected our decisions. And I said, well, I mean, if you come from Mexico, you will think differently. At that time, that was not a major risk. Today, that's a major risk in Mexico. So fortunately, in Mexico, the competition authority is an independent, is constitutionally independent. So it's as independent as the central bank or as the Federal Reserve here in the U.S. So it depends on the culture of the country and depends on the realities they are going to face. But that's what I consider that regardless the way the reality in which you are based, independence is a key element. Second, you have to be perceived, and you have to behave in a neutral way. You have to be perceived as an unbiased authority. You have to treat everyone with exactly the same line. That's not an easy issue, and that it is very important because that goes very much in line with what the economic agents consider the way that you are behaving. Number three, you have to be obviously technically strong. You have to be technically solid as an agency, and I think you have to behave very much in line with best international practices. Number four, you have to be efficient. Efficiency goes basically with the way you design the incentives within the agency, and that is very important. That is crucial. You have to have the right incentives in the way you design the agency's design. And finally, transparency and accountability. That's crucial. You have to be a very open communicator all the time with the practitioners, with the public, with the economic agents, with obviously other agencies internationally. And I totally agree with Jim when he says, when he was saying that you have to be very communicative within the agencies of your own country.
Thank you, Eduardo. And I think it's interesting that Boyana, coming from the privacy world, Eduardo coming from the competition world, have defined principles that I think are quite generally applicable across the spectrum of what we do. Are there others who would like to come in on this topic? Rod.
Well, I'll just add a couple of other points because I completely agree with the points that have been made. But I think a regulatory agency has got to be and be seen to be a strong enforcer. It has got to be taking people to court and be seen to be doing that, as well as doing market studies where markets aren't working as they should. I think they are complementary things to do that have the regulator doing their job properly. So that's one thing I'd add. And the other thing I'd add is that I think the regulator has got to be a constant communicator. It can't just be doing things. It's got to tell people what it's doing. Otherwise, it's just not doing its job. And part of that is, I think, as an advocate for competition,
if the competition regulator, I mean, we're both the competition regulator and the consumer regulator, if we're not advocating for competition and advocating for consumers in Australia, nobody else is. So we have to be a constant advocate.
So I just wanted to sort of come back on one point, Rod, Eduardo, you have actually prompted me. What is, I think, different in this world of fourth industrial revolution, and what should regulators do, is that we have this asymmetry, and somebody talked about informational asymmetry between consumers and tech world, but actually there is asymmetry, regulators and this new tech world. So what does it mean to be technically strong? It means also having capabilities to understand the technology and the world that we regulate. We are now regulating the world of data, and there hasn't been anyone else who has ever regulated data. And this world is so different and new and so changing that I think we need to completely step up and reinvent ourselves as regulators. I'm speaking as though I'm a regulator. I'm not. I used to be a privacy officer in a company, but it's the same. You know, internally, when we deliver privacy compliance, have to completely change, and regulators have to change. And so I think that's why I think this constructive engagement, where there is a feedback loop of reiterative compliance, learning from each other, understanding, using sandbox, using citizens' jury. This is something that ICO in the UK is doing now, is actually something that would serve us better as regulators at the moment, because it is a new, brave world that we are regulating. And I think the old-fashioned methodologies are just not going to cut it anymore. So that's perhaps a challenge for us.
All right, you've thrown down the gauntlet, and I think we have Andy and Terry who are also interested in coming in on this. Andy?
She has certainly inspired me, but so did Mr. Rill. I just want to combine the two, really, because we're just done with a very large study at the OECD across 14 different policy committees looking at what we call the digital transformation. I think Bojana's comment is absolutely right. That data now cuts through almost every area. And so going back to where Mr. Rill was, is just that I think you need competition and consumer protection authorities to begin to work with departments of transportation, where there's a lot of data, departments of health, or agencies like NIH that have a lot of data and don't necessarily understand always the properties associated with the marketplace as an FTC would.
I don't want to be a skunk in the woodpile, but I just can't resist the temptation. I think the FTC's record as a regulator has been mixed at best. And that's because I don't think it is a regulator, nor do I think it should be. I think the U.S. agencies, unlike many other competition agencies which have true regulatory powers like the ACCC, the FTC and the DOJ principally do not. They're law enforcement agencies. They're not regulators like the Federal Reserve Board or the Federal Communications Commission. And while there are some residual powers, for example, within the FTC's organic statute and within Magnuson-Moss Act, where the FTC can look at a market, find that it's not operating the way it would like to operate, notwithstanding the absence of any violation of law, it can do a market study, but a market study plus, and then impose a regulatory regime that has the force and effect of law. And the agency was fascinated with these powers in the 1970s, and I think no one would disagree with me in saying at the end of the day, the record was at best mixed. I think in the United States, we're not really regulatory agencies, we're law enforcement agencies. And while that may seem like a semantic difference, I actually think it does impact the way that the agencies do behave and, frankly, how they ought to behave. And I don't quarrel with agencies that have mixed roles. I mean, the ACCC, I guess, is a classic example where the Australian legislature has vested it with powers that are broad-based, and many other agencies are like that, too. I don't think that's the role of the U.S. agencies.
Good. We're off to a rollicking start here. Now let's take these insights and focus the lens on the FTC's bilateral relationship and international cooperation. As we heard on our panel this morning, we operate in a world where agencies are housed in all different legal systems and economic cultures and histories and powers. how can the FTC be effective in operating in that environment, and also are there things we can learn from some of the other systems and tools that other agencies may have that can enhance the FTC's ability to be effective. Let me see if we can start off our discussion with some observations from Rod, whose agency mirrors our own in the breadth of our engagement.
Well, it's hard to come up with too many suggestions for the FTC, because I think your interaction with international organisations is sensational. Your cooperation with various agencies, at least as we experience, is terrific. So but there's nothing to say there, just to say, but to thank you very much for that. The areas of improvement for cooperation, I think much better information sharing. I know that it was mentioned earlier, particularly in Marcus's section, trying to have the competition agencies more emulate what IOSCO does in terms of information sharing would be extremely helpful. And also, although I'm hesitate to give up our uniqueness, but we have Australia has a treaty, antitrust treaty with the US that allows essentially the US agencies to act on our behalf, which is stunningly powerful. We don't use it that often because we don't have to use it that often because people know we can use it. And I think if that, even though, as I say, I really appreciate the uniqueness and I hesitate to lose that status, but I think more of that sort of cooperation would be just tremendously powerful in making agencies more effective worldwide.
Well, we'd like to make you more of a path breaker than a unicorn in having more of those agreements. Andy, dealing with a lot of consumer agencies and privacy agencies in the context of the OECD, what do you see that we could bring into the FTC to enhance our bilateral engagement and cooperation?
Well, again, I agree with Rod. You're already doing a whole lot, and it's been really, you've been playing a leadership role at the OECD for some time. All the way back to 2003, we put out the best thing we have as a policy recommendation, which is called a council recommendation in the area of guidelines for protecting consumers for fraudulent, deceptive commercialization practices across borders. That has really acted, it was launched by FTC and then FTC Commissioner Moselle Thompson. And that has stood the test of time. We just reviewed it a few years ago in 2018, and it set out a number of different modalities that countries can follow to get this cooperation going. And we found that, you know, across 31 countries we were looking at, only 2 didn't have something pretty well established. And so I think this is a exemplary role. As was just said, there's some limits here, though. We can always do better. This is the OECD. We always encourage more, and that's the implementation challenge, particularly with sharing confidential information, is difficult. And I think this is an area for maybe further work.
Great, thanks. And Eduardo, from the perspective of the competition landscape that you observed from the ICN and elsewhere?
Yeah. Let me say that what I could see from other agencies that could be used or could be applied in the FTC, I will start with the same general idea of the best design of an agency, and how you can use that best structure in order to be applied in different jurisdictions. And I think independence is still a very important element. The way the commissioners are selected or are appointed is important. It's something that as long as you could separate that process of decision from political elements, and you can put it in a more technical area, I think that's going to be useful, and I think that's something that has been seen in different countries, and Mexico, I think, is not an exception of that. I would say that the case of attribution of merger cases would be also important. Something that we didn't have in Mexico until recently, until 2014, and something which you have been living with in the U.S. is that the fact of having two agencies dealing with the similar areas, that's difficult itself. In Mexico, that started in 2013 with the basically separation of competition application or competition enforcement in the telecoms regulator. Even though that is a little bit more specific, there are some gray areas where as a practitioner, now I am on the other side of the table. It's difficult to understand who decides what, and I think there is much to do in that line to give more clarity to the private players and practitioners in general.
Right. Now, we have a lot of private sector stakeholders with a keen interest in our discussion. Is there a constructive role that the private sector can play in helping the agencies be effective or in facilitating good cooperation?
Well, just to make a couple of comments, I think that the private sector can play an important but limited role. The agencies need to always be in the driver's seat, in my view. That's not to say that there isn't a role for the private sector. I think that there is. It can be a very valuable sounding board for proposed changes in regulation, law, and policy, where provide information that the agencies can take on board or not, but nonetheless hopefully consider. I think that's a valuable aspect. Secondly, the agencies have, the private sector has resources that sometimes can be used to augment those of the public agencies, and the ICN's use of NGAs is, I suppose, an excellent example there. So I think there's an important role for the private sector, but I think it is, as we phrase the question, helping the agencies.
I sort of, it's a little bit of a tangential comment, but in privacy in particular, one thing that we are seeing, unlike competition, and I totally appreciate that, is that private sector is playing increasingly important leadership role in shaping global responses to these diverging privacy rules that exist globally. So we don't have one privacy rule. We don't even have it in the US, which we should, but that's a separate discussion. But globally, there isn't one. And I think what we are seeing is the multinationals filling that vacuum and applying reasonably coherent privacy requirements and rules wherever they operate. And they have these accountability programs, privacy management programs. And so I think there is something there, Randy, that I think FTC should be exploiting and kind of using that to also promote organizational accountability. I actually don't think that everything in privacy certainly can be solved by laws. Technology is just too far out of the corral to be able to be tailed back. So we need these different methodologies to co-regulate, not self-regulate, but co-regulate through accountability models that can be also certifiable. We have seen a great example in privacy, in so-called cross-border privacy rules that have been jointly adhered and approved in the APAC economies. US is one of that. Those economies, FTC has played a really important role in building these cross-border privacy rules, which act as a minimum base standard, if you like, across the APAC regions and enable companies to share data accountably and responsibly, and therefore promote consumer trust and confidence in digital economy. And so I think those kind of accountability measures that are based on private sector stepping up, but with the regulator who is incentivizing and rewarding those kind of behaviors would be really very, very important. And may I also say, I want to remind all our colleagues here, we have had a very interesting project years ago, so-called Privacy Bridges project, where we tried to bridge differences between regulatory approaches in Europe and US. One of that recommendation from that report came out to say that regulatory agencies should be doing not only joint enforcement, which we see at the moment, but also joint policy setting and potentially even joint guidelines. And I think this is something to also explore.
Well, thank you, but you've mischaracterized your comment as tangential.
Sorry, I can go on massive tangents.
It is indeed central, and I think it's a perfect segue into broadening our discussion from the realm of bilateral cooperation to more policy-oriented convergence. So with scores of agencies in the privacy and consumer protection and competition business, I think we all agree that it's impractical, unrealistic, and highly undesirable for each to be off on its own without any coordination. At the same time, there is no unifying supranational hard law in this area. There won't be, I think, despite Tad Lipsky's desire expressed earlier, and my personal view, that's a good development. But where does that leave us in terms of the ability to use what the previous panel discussed as soft law in promoting good practice, in identifying best practices, in spreading them, and what role can the FTC play in doing that? So I'd like to ask everybody really, what are the areas you think that are most important for the FTC to encourage convergence, and how should they do that? And are there areas where they should avoid preaching convergence because there's room for experimentation, and are there less good practices that we ought to try to be warding off in the world? So big question, and let me ask Terry if you can lead off our thinking on this.
Well, I'll just very briefly toss out some things that I think are important. I'd focus on the consumer welfare model, which I think has served us well over the last good number of decades in both Republican and Democratic administrations, and which frankly is under assault at present. I think due process is an area that all of us ought to be concerned with. While I don't have any significant criticisms of the U.S. System as it's employed, due process is certainly lacking in other places around the world, and I think that there's a great deal of very profitable missionary activity that ought to and can take place there. I think in the area of privacy, or privacy, however you want to pronounce it, it's obviously something that all of us value. But that doesn't mean that you raise your hand every time somebody says you want more privacy. I believe you always need to think about the interface between competition and privacy and strive to reach the right balance. And I think that's a very, very difficult challenge. Easy to say, harder to make work. But I'll just toss those out as some ideas.
Great. Well, let's go down to the end of the table. Andy, do you have thoughts on areas ripe for convergence efforts?
Yeah, I kind of expressed it before, and I like to think that organizations such as the one I work at can help bring this convergence, at least show best practices, and once in a blue moon, worst practices. It doesn't happen as much as we would like, but and to go back to, I think, a common thread of this panel, I do think kind of a new factor of production for today is data. This raises some interesting questions both for competition authorities, but data protection and privacy. So there's a convergence area right there, I think, that needs that I think FTC is perfectly poised to begin to look at, and I think you're going to see this competitive advantage associated with data go way beyond the companies we think about today. And I just think about more traditional companies such as John Deere, who are now making very creative use of data in many different markets. simultaneously, and there's a bit of a debate in some parts of the world, who owns that data? Is it the farmer or is it John Deere? And that's just one dimension of this. But I think that is a convergence area that is worthy of attention.
Rod?
Well, look, I'm going to slightly agree with Terry. I'm going to be careful how far I go here. But I mean, I think promoting the consumer welfare standard is an important thing to do. I noticed James Rule mentioned national champions. I mean, I've been jumping all over that every time it gets mentioned. So going back to my point about advocacy, we, and particularly I, have been a very strong advocate against national champions every time the business community mentions it, because they do just about every time there's a merger. Every time the governments mention it, because they do, every time they want to justify things they've done. And I think unless the competition agencies are jumping over that, nobody else will. So that's where we absolutely need to be an advocate. But the consumer welfare standard is obviously a sensible grounding for determining what, and we are an enforcement agency, what as enforcement agencies we should be focusing on, and how do you separate pro-competitive and anti-competitive behaviour. I guess the caution I would put with it, though, is I think in implementing the consumer welfare standard, which, as I say, we strongly adhere to, we just need to be a bit careful as we promote it around the world about the evidentiary burden we're seeking to impose as well, and the way we're complicating cases. Competition policy, I was very taken by Han Lee's point that competition's very technical and economic and legal, and consumer is not. Our consumer and competition staff are one, they're melded into one, and they're all basically economists and lawyers. We've got a few ring-ins. But the point I want to make is we do complicate competition cases, and we do sometimes put on a very large evidentiary burden. I mean, we've just taken a case in Australia where the New South Wales state government put in place a system to penalise, so they sold 2 ports to the one player, which is a bad idea in the first place, and they put penalties on the third potential port, which was sold to someone else, so that it couldn't compete with the ports they'd sold. Now, that's a case we took with great, well, glee is the wrong word, but enthusiasm is the right word. Of course, we're not there spending a second trying to work out what the harm to consumers are. It is patently self-evident that there is harm to the competitive process, and we took it on that basis. So I just want to make sure we're not overcomplicating as we promote the consumer welfare standard. Don't make it so technical no one wants to touch it.
Great. Eduardo, would you like to come in on the convergence point?
Yes. Well, let me just put that question in a kind of slightly different background, which has to do with the role of the FTC today with respect to international organizations. What's the way, or how I would like to see the FTC role at this time? And I go very much in line with what Rod said. I think that advocacy is a key element. Advocacy, even though that the agencies, competition agencies, are very much in they have the obligation to apply the law, to enforce the law. They have a broader obligation also to press and to advocate for efficient markets. And today, that is something that is at risk internationally. The role of the FTC as an advocator, long time ago, well, not so long time ago, but it was when the ICN was created, and the grandfather of the ICN was just present here, was precisely to advocate for that internationally, to advocate for efficient market-oriented policies through the application of competition and enforcement of competition law. We are now living in a very difficult reality internationally that puts at risk the consideration of market policies and market efficiency, promote the promotion of market efficient policies. So I think this is a good moment to think about what should be the next step for the ICN, and what could be the role of agencies like the FTC, like the DOJ, or even the European DG Comp in this area. And I think that as they had this important role a few years ago with respect in the creation of the ICN, I think this is a good moment to think what should be the next step for the ICN. And in my view, the next step for the ICN, or the next reflection, has to go in line of a creation of an organization, a more formal international organization, in order to keep promoting markets to be efficient. And I think the FTC is in this important historic moment to take a decision on how to move forward. If it's needed, if it's useful to think of an international organization with a permanent secretariat to defend the market-oriented policies, how to do it, and how the jurisdictions and the countries that want to be part of that should be joining, and what kind of conditions should be designed in order to do that.
Well, thanks, Eduardo, and you'd left us still a little bit in suspense about next steps, and I know that you have a strong background as well in the trade world from your days in the WTO, and I may come back to you to see if you think the ICN's all antitrust all the time motto is still apt in today's world, or we ought to be looking more broadly at intersections with other such policies. But now let me come back to Bojana to ask how you think this convergence idea or agenda might play out. Is it relevant in the world of privacy authorities? And I'd like to interject into that a question from our audience, which is, what do you think is the greatest obstacle or the obstacles to privacy agencies collaborating on best practices and guidelines, especially between the United States and the European Union, and how can we overcome those obstacles?
Yes. $1,000,000 questions. If only I knew this, whoever asked me that, I think we would be very rich and we would solve all the problems. But seriously, it's a bit of a loaded question, right? Because we assume there are some obstacles. And whoever has asked me, I think there have been some obstacles. And maybe some people would say there's been a little bit of erosion of trust between regulators in the EU and here on this side of Atlantic. Some people would also may say there's been a bit of we have different philosophies, and therefore we kind of focus on these differences as opposed to something else. But I would like to be a little bit more optimistic, and I actually think there is a path forward. So first of all, there've been great examples of this kind of bridging and collaboration between EU authorities and the FTC in the context of Privacy Shield. FTC has been a phenomenal, not only supporter, but a knight with the shield, using the shield really in the way that it is supposed to be used, and has hugely contributed to acceptance of Privacy Shield as a proper transfer mechanism. For those of you who are privacy geeks here, you know what I'm talking about. There's been a great collaboration between some of the regulators in the EU and FTC through GPEN, Global Privacy Enforcement Network. I think that shows that things can be done together. There are a number of memorandums of understanding, as I understand, between individual agencies in the EU and FTC. So there are lots of these things that actually have worked already. Now, but how do we move forward? I think there is more that brings us together than that actually pulls us apart. And we have to both, on both sides of Atlantics, just like that Privacy Bridge project was about. It was about finding an adapter. Like when I come here, and I really get annoyed with English plugs. I hate English plugs. And we've got continental plugs and British plugs, and we've got American plugs. But we have to have one electricity, but all these different plugs. So that's what we need to find. We need to find some plugs in between so that we can live with these differences and we can translate what we talk together. And that means respecting each other's philosophies and background and constitutional frameworks. It doesn't mean imposing European values on the US. And in fact, I'm really emboldened by European Court of Justice Attorney General opinion on the case, which actually relates to whether the right to be forgotten should now be expanded globally at google.com, everywhere, including the US. Well, frankly, that would bring huge crash of cultures and constitutional frameworks of First Amendment versus privacy. And that's not what we want. And the Attorney General has very cautiously kind of said, well, there has to be a limit to how far we can apply these rules, even though it's a fundamental right of data protection. So I hope the court is going to uphold that. And I think it is important that we in Europe do not believe that our way is the only way. And I think we must be also humble to take on some of the US best examples. But then US also, we've got expectations. The US federal privacy debate is going to sort of stir up and come up with perhaps some new ways of dealing with some of these issues. So I think building on that respect for differences, but also what brings us together is a really good way forward. I talked about some of these joint policy initiatives. I really think this would be a great way to bring us together. Think about facial recognition or blockchain or machine learning. There would be, or Internet of Things, drones. All of that would be amazing. For example, case study to bring us to work on something which is proactive, which isn't kind of reactive, confrontational, adversarial, but actually we're creating something better for the world ahead. Of course, cooperation in enforcement is important, and I think as some in Europe do not believe any of the complaints end up in right hands. I think that's where FTC can also help and ensure that the EU-led complaints that are sent to the US actually get heard properly and get enforced potentially, or there is a feedback loop back. I think that would be helpful as well. And then final point I would like to add, which is something more around, as Eduardo has said, about the leadership role of FTC. I really think actually FTC has got something to teach other regulators, just because of its breadth and sort of experience in being a tough enforcer. Those of you who were in privacy for many years, you used to remember people used to say, Europeans used to say, if only we had the FTC enforcement and European law, that would be the best combination. So we always looked up to FTC as to how they enforce the law, how they manage. And I think that's something that FTC can really take on a great role, particularly with European regulators who now have got similar enforcement powers. But frankly, and I apologize, I know it's going to be online, they don't have the know-how, how to actually use these powers in the best way. We've seen some draconian enforcement in EU without proper due diligence, without proper process, without proper transparency and proper lessons learned, why that fine has been applied in this way and why it hasn't been applied that way. And I think this is something, Rod, I think you kind of slightly talked about that. That is where I think FTC can help also, frankly, technically bring the other regulators a little bit up at sort of higher levels, simply because of its standing and experience in enforcement.
Thank you, and I think we have a wonderful example of how your questions can really stimulate the panel. So, feel free, please, to find those cards, send them up here, and enhance the show. So we're talking about convergence and joint projects of an exciting nature, and one way to potentially move those forward is through the vehicles of international organizations. Our hearings have touched many times on the OECD, ICN, ICEPEN, we have UNCTAD, regional organizations like APEC, various privacy groups. There's a big menu of these venues, but resources are finite. Let me ask, where in surveying that spectrum do you think the FTC should allocate its resources, and what should they seek to accomplish in some of these important international fora? Rod?
Well, I wouldn't mind just, I'll answer that question, but just backing up.
We'll come back to any other point, please.
Well, what Boana just said, and we notice this quite a lot in our consumer work, because we are a consumer and a competition regulator, and because most of our staff do both competition and consumer work, we don't separate them out. I think we're fairly unique in that, but it just strengthens the process, that know-how in competition, which you've got to have be in the game. When you translate that into consumer work, is just so immensely powerful. I think on average, we would take larger companies to court for breaches of consumer law than we do for competition law. We've recently taken Ford, Heinz, Apple to court for breaches of our consumer law. We've got large fines. Perhaps the biggest development in Australia is we've just convinced the government, under the heading of advocacy, to align the penalties for breaches of competition law and consumer law. So now the penalties will be the same. Previously the penalties were much lower for consumer law, which is a terrible thing. The harm you can do through misleading consumers is visibly as bad as it can be from cartels. There's just no doubt about that. I can give you numerous examples. So I just want to back up that point, that the strength of being the regulator that does a number of things is important. And I guess it leads into my point that I think ICEPEN's the organisation that perhaps needs that extra bit of work, whether it's capacity building with new jurisdictions, whether it's more coordinated action amongst the members, whether it's common approaches and practices, but really just raising up the profile of consumer work. I have to say I continually get irritated when I'm at international meetings. You get the sense that competition work is held to be in some way superior to consumer work. That is complete rubbish. They are equally important. If you want your market economy to work for the benefit of consumers, you need effective competition law and you need effective consumer law. They can both equally do great harm, and so I just think we've got to raise it up.
I think you have a sub silentio round of applause in the room there, Rod. Not to mention from Boyana, who mentioned privacy,
And
which we
privacy
think
as
of
well,
as
so we
part of our
volunteer.
I can't talk about privacy, but
Three-headed Medusa is with three heads, right?
but I would happily push it to privacy, absolutely. Well, the same point applies, and it was Boana's point that got me in there, that same point applies.
And would anybody else like to come in on where we should focus our efforts in the international organizations? Eduardo, you talked about that maybe we ought to be going to the next step. So if you'd like to elaborate on that.
Well, yes, I could, I mean, in a very general way, elaborate a little bit more on that. Let me first, let me start with the main features of the ICN. The main features of the ICN, in my view, is that, well, it's a sub-law organization. It's a consensus organization. That goes very much in line with what happens in the WTO. It could be risky, but that's the reality. It's a virtual system organization. It's a virtual network. It uses very efficiently the communication technologies and so on. And the main products that are created by the ICN are this best international practices, standards, practical guides and toolkits, and they organize workshops for members. I mean, that's in a very general, and schematic way. Well, the first question is, that has been, in my view, that the ICN has been one of the most efficient networks I have ever seen, international networks that I have ever seen. When I compare how the ICN was created and what was the situation in the context of the WTO discussion on trade and competition, which was one of the elements that provoked the creation of the ICN. And if you see that was 2001, more or less, I think it was 2001, with 15 members in the ICN. Today they have more than 140 members. In 2001, the WTO was working generally well. We were in the middle of, in the start of a new round, the Doha round. At that time, the ICN was created, and the ICN has been much more effective, frankly, than organizations like the WTO. But now my point here is that in the international context in which we are living is highly complicated. I mean, there are a lot of nationalistic pressures, national champions, pressure from different countries, developed and not, and developing countries at the same time. That has become, I would say, a more systemic, risky problem for markets. And that doesn't mean, I mean, the most important elements is how to show that markets in a competition scenario is one of the most important instruments you have in order to create not only efficiency in your economy, but also equality of opportunities for economic players, for economic agents, but also at the same time equality of opportunities for consumers. So in that situation is where I think it is needed to give an additional impulse to an international organization or an international network like the ICN, and maybe I'm basically suggesting to reflect on the possibility to create a new organization, a new international organization of it could be consumer and competition agencies, obviously, and that should be a more, in my view, should be a more formal organization in order to generate an international pressure for the evaluation and valuation of the importance of markets in that context, in the context of competition. So to think about the possibility of having a formal and permanent secretariat, that makes a difference because today what you have is the members. The members are the secretariat itself. So it's difficult to differentiate of what a jurisdiction is saying or what the organization is saying, because the word is the same. So in my view, you need someone that is more independent than the agencies in order to advocate for competition in different jurisdictions. It has to be a product, in my view, from an international agreement with some cooperation mechanism, but also with some monitoring mechanism. And that's the most, this is a difficult task. I'm not saying that it is not. It's a real challenge, but frankly, what we are living internationally is a challenge itself today.
Yeah.
Sorry for taking.
No. A lot of food for our continued thought. Andy, from the OECD perspective, what role can you see for the OECD, and how can the FTC effectively engage within the OECD, for example, in the Consumer Committee or in the privacy activities of the organization?
I'll touch on that just one second. Eduardo provokes me because my part of the OECD has done a lot on telecom dereg, particularly in Mexico, and Here's maybe an example we can begin to think about, because we did something in 2012. It helped inform the decisions and the regulatory reform that went on in creating an independent regulator even. Then We followed up in 2017 and looked at implementation, what really went on, and that's now become a lessons learned that the rest of the region now is beginning to look at. So I think there's a model for what he's saying. The FTC, I speak under the chair here of my Consumer Policy Committee, Hugh Stevenson, already plays a huge leadership role at the OECD. There's two areas, if I had to put on my Christmas list from FTC, where I'd like to see them push. One is on this evidence base that many people have talked about. Can we begin to, we love statistics at the OECD, and comparative data, comparative indicators, and can we begin to look at things as we get, for example, like data breach laws from around the world? Can we begin to compare these and get some, may not be apples to apples, but at least fruit to fruit to look at? The other is really leadership work that happened in 2010, again led by the FTC on our consumer policy toolkit, that I think they began to open the thinking on both behavioral economics and informational economics, which I think is important. And following up on that, and we've begun to do some work on consumer attitudes towards trust. It goes to what people were saying. There may not be such big differences as people think, but also doing some more experimental work, such on personalized pricing, which we're beginning to see proliferate in many different areas. These are areas where I think there's a lot of international interest and where the FTC could play a leading role.
Well, leading is leading right into our next topic, which is the FTC's leadership role. I think there was a point in time when the FTC had so much longer and deeper experience in some of these areas that it was a default and natural leader. Now we live in a very multipolar world in all of these disciplines, and it prompts me to wonder, what does it mean to be a leader in this environment? Is it important for the FTC to be perceived as and to be a thought and policy leader? If so, how can the FTC exercise effective leadership internationally, including on emerging issues and with agencies that operate in very different environments? So let me just run down the table for anybody who would like to offer thoughts on this, starting with Bojana.
Yeah, sure. So I've got a very long wish list, which I will submit in writing probably to my friends at FTC. But Andy, to continue where you've kind of stopped, I would really love FTC. I think there is some leadership vacuum first, let me say, in privacy regulatory community at the moment. And I think FTC would be very, very well placed to fill that vacuum together with some others who across the world are kind of wanting to seek that new leadership role. So one area where I would like to see some work on would be in the area of fairness, fair processing, fairness and unfairness. In majority of data privacy laws, we have requirements for fair processing, yet nobody knows what it means. Yet here, FTC statute and work is based on unfair trade practices. There is unfairness methodology that FTC can teach us a lot in this world of AI and machine learning as to what creates harms to consumers, how do we measure that, and how we as organizations think what is fair, what is not fair. I think this would be a great opportunity, not just for bilateral, multilateral regulatory cooperation, but together with the organizations who are implementing this in the practice as well. FTC anonymization test, again, for those of you in privacy geek community, is still standing the test of time, where frankly everybody else there's no such thing as anonymous data, because everything about me, it doesn't matter if you know who I am, but you know everything about me, that's good enough to identify me. Well, I think FTC again has done some really great thinking in the past, and we need to revive that leadership and kind of again convergence with some others. Risk-based approach to regulation and enforcement and investigation is something that I think FTC again is best placed to teach the rest of the world. We live in a world where data is everywhere. Every company, to your point, is today data company, Rod. I mean, I keep hearing this from manufacturing company to financial companies who say we are data and tech companies today. So in that world, we really need different ways of approaching that. And then final point, I would like to say that this whole topic of incentivizing what good looks like and rewarding good behaviors. I think there is something about that we need to exploit more. I've been head of privacy for a huge multinational company for 12 years, and trust me, when we got good praises from a regulator, that gave me bigger budget, that gave me more standing internally, that got me to speak to the CEO and the board much quicker than any penalty and any fine did. And I think realizing what motivates companies and motivates people to behave well and be good corporate citizens in this new interconnected world, I think there is work to be done there. And I do remember FTC consent decrees that I have read as I was a practitioner. Every single consent decree said to me, here is how they reward companies who actually do something well in privacy. Well, that's what DOJ did. I think somebody mentioned before. That's what SEC does. That's what U.S. sentencing guidelines do. So I kind of feel there is this U.S. body of work and it's not even it's legal background and framework that actually exists and can teach the rest of the world how to use those incentives and rewards for compliance in this new world, where I think this would be particularly useful.
Thank you. So as we go down the table, and as I see the hourglass time running low, thoughts on FTC leadership and any other closing thoughts you'd like to include in about a minute and a half each. Terry?
Minute and a half, okay. On the perception issue, you can go to Google and you can find a gazillion people, not a gazillion, but a large number of people that say that the U.S. agencies have failed to export the U.S. view of competition law and policy around the world. And I think in some sense that's a red herring. If you were to ask yourself, have they been successful in selling the treaty? Absolutely. And one would expect them to be. I mean, the treaty, in Ireland, we just go Xerox, Article 101 and 102. It's real easy to do. If you wanted to Xerox the U.S., what in God's name would you do to do that? The Section 1 of the Sherman Act is not very helpful. It's a common law, judge-made common law that we have for competition law in the United States. It's not a user-friendly exportable commodity. The same thing is true on the process side. Our legal process side is firmly grounded in the adversarial process that we took from England, where the agencies, generally speaking, stand in the position of the Crown as a party plaintiff before the courts. And it's obviously a hell of a lot easier to sell the administrative process to jurisdictions who owe their history to the continental system. So I don't find the fact that Article 101 and 102 have been adopted around the world. I'd be surprised if it hadn't been. I don't find it bothersome that a adjudicative administrative program has been adopted and the adversarial process hasn't. I'd be surprised if it were otherwise. I think the agency has been very successful in focusing on discrete and important topics. We may have duplicated Article 101 and 102 in Ireland, but when it came time to look at our merger guidelines, we basically, I guess we're being filmed here. We basically Xeroxed the U.S. Guidelines and tinkered with it a bit to make sure it fit our system. So I think the perception, sometimes this is a bit of a red herring. You've got to ask, really, what are we talking about?
Eduardo, what are we really talking about?
Well, I coincide with Terry. I mean, the legal system makes a major difference. But let me tell you, in the case of Mexico, we frankly used when we started the negotiations of NAFTA, we didn't have competition law at all. That was a little bit more than 25 years ago. There was not a competition law in Mexico. And we basically used, with the help of the OECD, we basically used the model of the FTC. So that's what we did. So an element of leadership could be in very specific elements, like I mean, we have an administrative legal system, a completely different legal system than the U.S., but we basically use the same design of the FTC, and that has and that has been useful. We basically use the knowledge, the human capital from the FTC. I remember the FTC helping the Mexican authority to communicate with our judges, and we created a very important human capital in Mexico in the judiciary to judge the decisions of the competition authority. And that was basically, even though that the legal system was completely different, that was an example of how you could apply the knowledge of the markets, the knowledge of the competition enforcement in general itself. And it goes beyond the legal system.
Right?
In the interest of time, I'm actually going to junk what I was going to say, and just I want to reinforce some of the things that Boana said. I think it's an extremely good idea for the FTC to exercise leadership in the data field, given it is the competition, the consumer and the privacy regulator. That is a fantastic combination. I had never met our privacy regulator in Australia, didn't know where they were, didn't know who they were until we did our digital platform inquiry. And then I finally located them. They were in the same building I work in Sydney.
Oh, no.
But I didn't know.
You met them in the lift?
Sort of,
Okay.
yes. So the fact that you're already at one, I think, is something that can be worked on. And I also want to support the concept of unfairness. In our digital platform inquiry, we are completely looking to the US on that, not just the way the law is done, but the way it's administered. If we were to press for such a law, we would try and completely copy the way the US is doing it.
You, Andy, last word.
I'll pull a trick from Rod and actually build on a comment he made earlier. I think after basically 40 years of regulatory reform, and then our economy is becoming more digitally based on the internet, which it really empowers the end user in a way we hadn't seen before, that the importance of consumer policy needs to be underscored. I completely agree, but I don't see it in many countries or at the OECD for that matter. And so giving greater weight to that and what that means, because we rely on them to make markets in a way that we didn't 50 years ago.
1 second left. Bingo.
Well done.
Thank you, but I will go over our time to thank you for an extraordinarily informative and interesting and fun discussion. Thank you all so much. Please join me in recognizing our wonderful panel in this discussion. Just stay and if you would stay where you are, we're just going to have a few concluding remarks to wrap up our hearings. Time has flown. Our panel time has flown. Our 2 days have flown. They've been an extraordinary couple of days. We had high expectations. From my point of view, they have been roundly exceeded throughout the program. We've had an extremely rich dialogue on the key issues that the FTC faces today and those that will confront the agency in the international aspects of our work, which will continue to play an increasingly important role as we seek to fulfill our consumer protection, privacy, and competition missions. None of this would, of course, have been possible without a truly extraordinary amount and quality of work by a huge number of people, so allow me a moment to offer a few words of thanks. First of all, to Chairman Simons, joined by our commissioners, for conceiving these hearings and supporting this hearing on international issues. To the FTC staff, far too numerous to name, especially from all my colleagues in the Office of International Affairs, to Bilal Said and his team from the Office of Policy Planning, who have run this and all the other hearings, from the amazing group from our Office of the Executive Director, working mainly behind the scenes, whom you may have seen, though, at the back of this room and outside this room, who not only made this happen, but ensured that our program transpired extremely seamlessly and professionally. Thank you, thank you. to our panel moderators from the Office of International Affairs, plus Ellen Connolly from OPP, and to our faculty who came from around the world, in some cases just for this hearing. Thank you for making the time and for all the preparation and thought that went into making these panels so productive and insightful. We've learned so much from these sessions, and that learning will greatly inform our thinking and the FTC's priorities and policies as we prepare for the challenges of the coming years and decades. Thanks as well to our audience and our stakeholders whose views we welcome at all times, and especially in comments that we encourage you to submit by the end of May as part of our hearings record. That concludes our 11th session of the FTC's hearings on competition and consumer policy protection in the 21st century. Please join us for our future hearings, including our 12th hearing, which will focus on the FTC's approach to consumer privacy, which will take place at our Constitution Center in Washington on April 9th and 10th. We look forward to working with you in furtherance of the FTC's critical missions of maintaining competition and protecting consumers. Thank you very much.